Hello, my name is Amanda Kleinrock, and I am an attorney with the Fair Housing Project at the Legal Aid Society of Palm Beach County, and I will be speaking about fair housing law for landlords. The Fair Housing Act prohibits discrimination on the basis of what we call a protected class. And there are 7 federally protected classes under the Fair Housing Act. Those are race, color, religion, national origin, sex, disability, and familial status. Familial status is having one or more individuals in your home that is under the age of 18 if you are looking to adopt, become pregnant, or get guardianship of custody over a child under the age of 18. So those are the federally protected classes that apply anywhere in this country. Our Florida Fair Housing Act is identical to the federal act. And in Palm Beach County, we have an ordinance that establishes 4 additional protected classes. Those are marital status, age, sexual orientation, and gender identity and expression. And in Dade County, there is also a source of income protection. For example, alimony, child support, workers' compensation, disability, veterans benefits. In Broward County, there's political affiliation protected class as well. So it's important to know the additional protected classes that are available in your county. Prohibited practices under the Fair Housing Act. There are the obvious ones, which are refusing to rent or sell on the basis of a protected class, such as someone's race or their national origin. There's also falsely denying that housing is unavailable. Establishing any different terms or conditions on the basis of a membership in a protected class. This applies to any services associated with housing, not just buying or renting a house. It also applies to appraising property, home insurance, zoning, and it applies as well to any amenities or services associated with housing. So if you try to restrict, for example, access to common areas or the swimming pool or the gymnasium on the basis of a protected class, that would be affected by the Fair Housing Act. It also affects the advertising that is used, a choice of words and preferences or limitations that you might indicate in an advertisement could be considered discriminatory, and choice of media used and models used for your advertisement as well. There is an exemption for the Fair Housing Act. I mentioned that familial status and age are protected classes. The exception came about as far as the Housing for Older Persons Act. It was one of the amendments to the Fair Housing Act, and it came about in 1988. Housing for older persons is exempt from the prohibition against familial status discrimination if the HUD secretary has determined that this housing is designed for and occupied by elderly residents under federal, state, or local government programs. But there's very strict requirements to be housing for older persons. You're supposed to register with the Florida Commission on Human Relations, and it has to be housing that's limited to at least 1 or more people in each unit is 55 or older, at the threshold of 80% of the occupied units. And once 80% of the units are reached as 55 or older, the remaining 20% can be less than 55, but the majority of them are designed to be 55 and older housing. The other option is 100% of the units are for individuals who are 62 or older. So we can never go below 55 or older or 62 or older, but one can go higher than that. Disability. I mentioned disability is a protected class under the Fair Housing Act, and it is a common type of violation nationwide. A disability is defined as an impairment, physical or mental, that substantially limits one or more major life activity. And a major life activity could be walking, sitting, breathing, standing, lifting, working. If it's a mental disability, it could be thinking or concentrating, the ability to care for oneself. You could have an obvious disability, such as someone who uses a wheelchair for mobility assistance, or you could have one that's not obvious, but you have a record of such an impairment, or you are regarded as having such an impairment. And there's no hierarchy of disabilities, whether a physical disability or a mental disability. They all have equal weight. So under federal and state laws, no discrimination is allowed against individuals with disabilities in the terms, conditions, or privileges of housing. and this affects requests for reasonable accommodations or reasonable modifications that may be necessary for an individual with a disability to use and enjoy their dwelling. A reasonable modification is a physical change to the structure of the building, and a reasonable accommodation is a change to the terms and policies of the community. A reasonable modification for the physical structure of the unit, some examples include if someone needs a handicap parking space, they might need a wheelchair ramp to allow them to enter their unit or a common area. Modified entryways, such as hallways that are widened to accommodate a wheelchair. Installing mailboxes that are easily accessible. Adding grab bars in a bathroom or a shower. Installing any kind of wheelchair lift for the pool or an elevator lift to allow access to a unit, and placing trash cans in a more accessible location rather than perhaps a common dumpster. So those are changes to the physical structure of the community or the unit. Reasonable accommodations, some common examples. If someone needs a live-in caregiver to provide them care for their disability, that could be an exemption, for example, to a restriction on age, a housing for older persons community. If you need a caregiver that's less than 55 for your disability, that would be an accommodation to that rule. If someone needs an electrical scooter or other mobile device, to use that in a common area of a complex where it might otherwise not be permitted. A common one is a request for an emotional support animal or a service animal in a community that otherwise has a no pet policy. A no pet rule does not apply to a service animal or an emotional support animal because those are not seen as pets. Those provide a service, and in the case of an emotional support animal, they provide care and companionship and stability to someone with either a psychiatric disability or with a psychiatric symptom of a physical disability. So you cannot charge deposits for these animals. You can't require special pet insurance or any kind of fees associated with them because they're not viewed as pets. You couldn't charge for them any more than you could charge for someone having a wheelchair or a cane. There's also no allowable breed restrictions on the basis of a service animal or an emotional support animal. If an animal is dangerous to the community and has proven itself to be that way, that could be an issue, but there can't just be a blanket restriction on all breeds if it's a service animal or an emotional support animal. Similarly, you can't restrict the type of animal, such as a dog or a cat or a bird, because any type of animal could be an emotional support animal. And you can't restrict the height or weight or require extensive verification. You could, mandate that vaccinations are allowed, but you can't require some special notarized affidavit or something that gets too onerous for the individual with a disability. And now I'm going to turn it over to Tequisha Myles, our supervising attorney, to talk about landlord tenant law. Thank you.
Once again, my name is Tequisha Myles, and I'm a supervising attorney of the Elder Law and Fair Housing Projects at Legal Aid. And I'm going to talk about your rights and responsibilities under the Landlord Tenant Act and the Fair Housing Act as a landlord. First, when you are screening your tenants, you want to make sure that you're looking at what is legal criteria. So you should be looking at their income, their creditworthiness, employment history, criminal history, and you should always ask for references. Things that are unlawful are things that are protected under the Fair Housing Act. So you can't look at someone's race, color, gender, familial status, or any of the other protected classes under the Fair Housing Act. It is a good practice and tip to make sure that you have a written rental policy that includes the criteria to live at your property, what occupancy guidelines you use, your availability policy, and whatever rental criteria you use. So if your criteria to rent to someone or screen them includes looking at someone's employment, income, and credit, that should be written somewhere in a file. Also, it's good practice to make sure that every tenant that you rent to has put an application in. So you can get a simple application online or create something, but you want to get some basic information about each person you're renting to. You want to make sure that whatever form you use, that it's completely filled out before you accept that tenant. You should also look and verify someone's ID, their driver's license, or whatever government ID they want to show you. Could also be a passport, and keep a copy of that ID in your file. You want to verify whatever rental history that someone puts on their application. Make sure it's from a credible source. If the person says they're self-employed, you can always request proof from their tax returns or a business tax receipt to show that they are actually self-employed. So some of the factors that also may influence your decision to rent to a tenant are court judgments. So anytime that you're renting to a tenant, you may want to see if they've ever had any court judgments against them. And you can do a simple search on the Clerk and Comptroller's website to determine if they have any previous outstanding court judgments. That may be an indication that they have some financial problems, and that may be an indication later on they may have financial problems with you and you may have to evict them. But just as a word of caution, you want to make sure that if you are using someone's court judgments against them, that their judgments that are not something that can be explained. There might have been an illegal eviction previously, or some sort of case that they're still trying to fight or resolve. So you want to make sure that you get the background on what judgments you're using against them. Credit is another factor that you may want to use to determine or limit who you rent to. If someone has a poor credit record, you want to make sure that it's clear to them why you're not renting to them if you're using their credit. You may want to have a policy that if you have a record of having credit challenges, that you may not be able to rent to them, but make sure you have that policy in writing. Also, if you get poor references from a previous landlord, that might be a red flag that you shouldn't rent to that prospective tenant. You could have a policy that states that criminal convictions for certain types of crimes could result in an automatic denial of a tenant's application. So you could have a policy that says if you've ever been convicted of a sex offense or a serious crime with a weapon, that you will not rent to them. But also just encouraging you to find out the story behind their arrest or their conviction, determine if there might be some things that have happened that might be explainable, and you might be able to give them a second chance. Now, the law allows you to have an oral agreement with a tenant. It's highly recommended that you have a written agreement or a lease, but if you decide to do an oral agreement, you should know two things. If you have an oral agreement and they pay their rent weekly, then it's called a week-to-week tenancy. If they pay their rent monthly, then it's considered to be a month-to-month tenancy. Where that gets important is if either party can terminate the lease, the oral agreement, under the Landlord Tenant Act under these two circumstances. If they pay their rent weekly, all they have to give you is 7 days notice to move out. If they pay their rent monthly, they have to give you 15 days to move out. What's not addressed in the statute is late fees. So you will not be able to successfully get late fees from the client or the tenant if you don't have a written agreement. A written agreement, a lease, or a contract gives you the ability to specify the terms of rent, termination, any rules that you want to govern the tenancy. Two important areas that you have to deal with as a landlord are making repairs in a timely manner and what are prohibited practices under the Landlord Tenant Act. As a landlord, under Chapter 83, you have a duty to comply with all building and housing codes. And those housing and building codes essentially deal with plumbing, electrical, and structural-related conditions. If it gets to a point that your property gets into serious disrepair and the tenant may withhold rent by sending the landlord a notice with giving the landlord 7 days to make or take steps to correct the violations or correct the repairs. If the landlord does not take reasonable attempts to correct the repair issues, the tenant may withhold rent from you. And the tenant may continue to withhold future rent payments until the conditions are resolved. Now, what is prohibited by the Landlord Tenant Act? A landlord may not engage in self-help evictions. So that means the landlord may not change the locks on a tenant, turn off the water, turn off the electricity, turn off the gas, or remove the tenant's personal property from the rental unit in hopes that the tenant will move out. Those types of scare tactics are illegal, and the penalty is that if the tenant sued the landlord could be liable for up to 3 months' rent for each occurrence, plus reimbursement of court costs and attorney's fees if they hire an attorney. There are two main notices as a landlord that you will deal with. The first one is a 3-day notice. 3-day notice deals with the rent collection. So you give a notice that says that the tenant has 3 business days, excluding Saturdays, Sundays, and legal holidays, to pay the rent that's owed or vacate the rental unit. The amount listed on the notice should not include any late fees or other costs unless you have a written lease that says you can do so. If the tenant offers you the rent that's demanded within the 3 days, you must accept it. The other notice that you'll deal with commonly is a 7-day notice. There are 2 types of 7-day notices. One is a curable 7-day notice, and the other one's a non-curable 7-day notice. And a 7-day notice is used for lease or rule violations. So a curable notice gives the tenant an opportunity to fix the lease violation. So it could be removing a car from the backyard that's inoperable, or removing a dog from the property if you have a no pets policy. A non-curable notice does not give the tenant the ability to fix the lease violation. And this is maybe if you've heard or your tenant's been arrested for criminal activity or is a major nuisance to the property or to other neighbors. So some best practices and tips, things you should know as a landlord regarding fair housing. You can never steer. So if you have a call from a prospective tenant and you want to discourage them from renting from you or discouraging from renting in a certain area, you can't do that. If you want to make sure that if you have property available, that you show all properties that you have available. You want to make sure that you only present facts about the property and community and not about the other residents or neighbors to try to discourage the person. You don't want to say things like you'll like this neighborhood or you'll like this unit because it's quiet, there are no children around. Okay. Occupancy standards and apartment rules. The basic standards is essentially 2 persons per bedroom. However, there is a HUD memo, it's called the Keating memo, that allows housing providers to consider other factors in determining occupancy standards like the parking space allotment, the load on sewage, plumbing. So you want to make sure that you really keep that in mind as you determine how many people can occupy your unit. You might want to put together some house rules or apartment rules that make sure that the tenant is on notice of what things you'll accept and what you won't accept, what type of conduct you won't accept. Record keeping is very important. Landlords should always keep a record of prospective tenants and residents, current residents they have living in their property, and who's lived in their property past. Also, what available properties they have at any given time. You should create a system with relevant information such as the date and time of calls that you receive for repairs, properties that you are showing to prospective tenants, and prospective move-in dates for potential residents. In each tenant file for each unit you rent, you should include a copy of the tenant's ID, the tenant application and related forms you used during screening, any background check results that you received on each tenant, and any correspondence you have between the tenant and yourself. Any notices, like a 3-day notice or 7-day notice you've had to issue to the tenant, rental agreement, any addendums to the lease, and any payment records. Hopefully with these tips in mind, you'll have a good landlord-tenant relationship. Thank you.